Good evening, students. Today we are going to discuss a case which has recently resurfaced the question of whether lack of motive plays a role when we look into the insanity plea. So, this is the case of Chunibai versus State of Chhattisgarh, wherein this mother, she basically is convicted for the murder of her two children, a 5-year-old and a 3-year-old, both of them daughters. And while she has been convicted by the lower court for murder, when the case has come to the Supreme Court, we see that there is a deep perusal by the Supreme Court of some of the factors which were involved and the plea that this convict had given during the trial. So let us look into this particular case. I'll just share the screen with you. So this is the case of Chunni Bai versus state of Chhattisgarh, and where we see that there is a murder which is committed by the murder is committed by the mother of two children, and she is in a situation of being convicted for murder for this particular trial. Please give me a moment, students. Yes. So this female is convicted for the murder of her children. And as we can see, the age groups of 5 years and 3 years are provided in the case. And post her conviction, as she goes for an appeal towards the High Court, it continues the conviction of murder against the female. But in the Supreme Court, this decision is looked into, as I said, a bit more deeply. So these children, they are killed by the mother using a crowbar, and the type of injuries caused are serious in nature. When they are brought to the hospital, they are declared dead. So even medically, the doctors have said that they had died before they reached the hospital. Now, a certain set of aspects which must be known for this particular case was that this female, while she was inflicting blows on both of the children, she declared, she was screaming the fact, and this has been established by various witnesses, that she's committing the murder of her children. And when her sister in law enters the room and then tries to inform the neighbors, her relatives who live beside their home, at that time also, this female, this convict, the mother, does not try to escape. She stays where she is near the bodies of her own children. And apart from that, while everybody collects at the scene of the incident, the murder, she doesn't try to escape even then, and then starts showing remorse towards the act that she has committed. So, as we have said, in the lower court, she is convicted for murder. She goes to appeal to the High Court, which continues the decision of convicting for murder. But when it comes to the Supreme Court, we see that the court breaks down the case. It starts off by saying that when we see that something is considered as a homicide, then we must further look into the factor as to whether it comes under culpable homicide, and then whether it is culpable homicide not amounting to murder, therefore punishable under 304 of IPC, or whether it is murder and then punishable under 302 of IPC, which was the case in this scenario. Further, the court also talks about the fact that there are degrees which are considered when homicide is present, culpable homicide is present. The first degree of culpable homicide is the greatest of all, and that is murder. Then the second degree is culpable homicide, which is punished under section 304 part 1. And then there is the third degree, the lowest degree, which is punishable by section 304 part 2. Now, essentially, the discussion logically tells us that when the punishment is serious, the mental element which is involved in the crime that you've committed is also quite serious, which means that when we are levying heavy punishment, like for in the first degree, and mostly in the cases of second degree also, there is the requirement of constitution of intention to commit the crime, which must be present. So the Supreme Court is hinting that if you convict somebody for murder, it is essentially required that they constitute a strong mental element to commit the crime, right? And that's what is reiterated here, that for murder and for these different categories of culpable homicides, there is the requirement of mental element which will establish the extent of conviction, whether it is first degree, second degree, or third degree. And here it has been very well mentioned that whether it is murder or culpable homicide not amounting to murder is dependent on the presence or absence of intention in the offender. If the intention to cause death or to cause such bodily injury as is likely to cause death, or the knowledge which obviously has to be a conscious one, that it is so imminently dangerous that it must, in all probability, cause death, or such bodily injury as is likely to cause death, and commit such act without any excuse of the risk, it would be most appropriate to categorize it as murder. So it is implying that there is a certain requirement for us to levy the liability for murder on an individual, right? On the other hand, it states that if the intention in causing the death or to cause such injury is not clear, then we reduce the punishment to culpable homicide not amounting to murder, and then move on to providing the punishment under 304 of IPC. Further, the court has said that in this case, it was required to prove beyond reasonable doubt that this appellant had caused the death of her two children and thus committed culpable homicide. This we do not dispute. It has been established that it has been proved that she was the one who committed the crime. She caused the harm. She has caused the death of the individual. But the question comes in: has it been done with the requisite mental elements which are required for the crime? Right. So here the court starts trying to delve into this question. It says that the crucial question is whether she had the intention to cause the death of her children, or had the intention to cause such bodily injury which was likely to cause the death of her child, as we have previously studied, or whether she has conscious knowledge of the fact that it is such an imminently dangerous act which will probably cause the death through such injury of an individual without any excuse to the risk taken. So again, the court is reiterating that there is a certain extent of mens rea which is expected from the woman for liability to be of the gravest nature, of the first degree. The court further says in the present case, the factum of homicide being committed by the appellant is proved beyond reasonable doubt. So we know she has committed the death, she has caused the death of her children, considering the nature of injuries received by the victims at the hands of the appellant with a crowbar on the basis of the medical evidence brought on record. We can state that she committed homicide, and that can certainly be inferred from the trial court and the high court. However, now the court digresses, the Supreme Court digresses, and it says we have certain reservations about such a conclusion being drawn by the courts below in respect of the proof of intention. So they have certain doubts about whether she had intention or the requisite mens rea to commit the crime. In our opinion, they say that it cannot be conclusively held in the present case that the intention of the appellant or conscious knowledge of what she was doing, a component which is required for mens rea, was established beyond reasonable doubt. So they are raising doubts in regards to whether she had the requisite components of mens rea required for punishing her for murder. Okay. The case of the appellant also provides that in the records, she claimed innocence and denial of charges when she was examined under section 313 of CRPC, where she raised a particular specific plea that at the time of occurrence of the incidents, she felt she was in the influence of some invisible power. So she makes a statement that she felt that she was under the influence of an invisible power. However, what was the problem is that she was not able to justify this plea. She did not provide sufficient material or evidence to prove her claim. Right. So we realized that through this claim that she was making, this plea that she felt that she was under the influence of an invisible power, she was trying to take, or it is implicit that she was taking the exception section 84, the insanity plea for the act that she had committed. We also know that where you raise an exception for against an incident, in that situation the burden of proof is on the accused to prove that those particular circumstances existed, right? Whether section 84 of IPC actually existed has to be proved by the accused as per 105 of the Evidence Act. At this juncture, it is also important to note that the proof required from the side of the accused is only of preponderance of probabilities, which means that we have to prove that for all practical purposes, from the facts and circumstances, a reasonable probability comes out that this circumstance may be present, that it creates a doubt, it creates this particular possibility of existence of circumstances which provide that maybe the mental element which was required for the crime was not present because the person at that time was of unsound mind, right? So we don't have to prove it to the highest of extent, we have to prove it to the extent of establishing that for all preponderance of probabilities, the circumstances hint at the fact that the person may have been of unsound mind to receive the benefit of the exception. Now, going further, we see in this case that the appellant was not able to provide the required information, the required proof in order to establish that she was legally insane. And that is why we also see that because of the lack of evidence, the trial court or the high court may have not taken much impetus to this particular aspect. But the court is saying, seeing the peculiar facts and circumstances of the case, the fact that this was in a rural setting where there is no access to proper access to education, medical facilities, in such situation where the judgmental power of such an individual may have been affected and the assessment of the same may not be easily possible, it must be looked into with caution. So the court is saying the facts and circumstances where the mother has killed her own children, she has declared the same, she has not escaped from the scene. These are all situations which must be given lot of impetus when dealing with such situations, and try to look into the fact that whether the facts and circumstances hint at the presence of the required requisite intention to commit the crime, or can we give the person a benefit of doubt? Okay. Again, the court mentions the bizarre and inexplicable behavior of the appellant, right? It does not provide for an explanation. Her conduct in the circumstances infer at an impaired mental condition, which the appellant described as an influence of invisible power. So the court is inferring that the facts and circumstances, the behavior of the female itself hinted towards her mental instability, right? The further it is mentioned by the punch witness one that when the appellant was left alone in the house and went to the adjacent house to get help from her uncle, the appellant did not try to escape from the scene. Right? Furthermore, we also see that the direct evidence in this, wherever there are cases where direct evidence is available that links the accused to the offense, it is usually not seen, or proof of motive or intention does not preclude the conviction of the accused. It is for this reason, maybe the Supreme Court feels that even in this case, the prosecution has not adduced any evidence to prove any motive or intention behind the commission of crime. Because we can see the clear link between the incident and the woman, there has been not much effort to look into these facets of motive and intention. But the court has again now made an important statement. It says that in cases where the plea taken by the accused is such that it raises doubt on the mental stability of the accused, the existence of lack of motive assumes great significance. This statement of this judgment is the most important statement. They are saying that where a plea exists of the accused being mentally unstable, and we are not able to establish a motive for the crime committed, these two things must be looked into with great importance by the courts, right, while assessing the case, while perusing this type of cases. This is especially true in cases involving grave offenses like murder, where a complete absence of any kind of motive which ordinarily impels a person to commit such a crime may lend credence to the plea of insanity. So again, this lack of this lack of motive on the part of the convict may hint at the fact in such cases that the plea of insanity may be applicable. The court states that where the mother has taken the life of her own children at a tender age, in absence of any motive, these could be situations where we must look into the fact that there is no motive and the mental stability of the woman may be affected. The husband of the appellant and other close relatives, as well as the resident of the villages, all acknowledged that this lady loved her children. So her behavior on that incident again repeatedly is being um, uh, it is being reiterated that it is not normal behavior on her behalf. Her father-in-law also, the punch witness 8, refused to believe that she had committed the offense against the children. The court further says in this background, in the absence of motive, assumes great importance, which in turn would put a question mark on the presence of intention to commit the crime. So, absence of motive hints towards the fact that maybe there was no intention to commit the crime. Thus, the inference one can safely draw on the basis of the evidence on record is that the appellant had a cordial relationship with all family members, including her children, and what the act that was committed seemed to be without motive, and therefore questions whether she had the intention to commit the crime. Post the incident, she was seen crying, bemoaning the killing of her own children. This also hints at the fact that she had remorse for the act that she had committed at the spur of the moment, which we can see that the Supreme Court has also highlighted. And therefore, we again see the court mentioning where the motive which can provide the basis of intention is not present, it seeks to create a question on whether intention itself is also present in the situation. So there are doubts whether the person intended to commit the crime, right? There was also questions raised regarding the fact that the state did not look into the fact, into the motive and intention for the commission of crime by the prosecution in the said case. And we lastly go on to the fact that what did the court finally conclude at? It stated that in their opinion, the plea taken by the appellant that she was under the influence of an invisible power during the commission of crime raises a reasonable doubt which can be said to have arisen as regards to the existence of intention, thus of mens rea for causing the death in the present case. In arriving at this conclusion, they have taken into consideration following aspects. During the commission of crime, the appellant was shouting that she is killing her children. Post the incident, the appellant, on being asked the reason behind her act, kept on crying and repeating that she has killed her children. The appellant did not try to flee the scene. Complete absence of motive was looked into for the commission of crime. The nature of relation between the accused and the deceased, that is of mother and child, and the absence of strained domestic relationships between the accused and the family for any kind of motivating factors for the commission of the crime were looked into. Finally, what is important that the court said we don't have enough proof, enough evidence to state that the insanity plea is available to this accused. But we do have enough information to create enough doubt that whether she intended to commit the crime. Right? That's what the court says, that there are circumstances which create doubts as to the fact that the requisite intention was present in the appellant to commit the murder, or whether she had the intention to cause the death of the two children, right? And therefore, because the required mental element, the mens rea, was not present in the crime, we see that the court changed the decision from conviction under 302 of IPC to part 2 of 304 of IPC, which is in third degree, stating that the required mental elements which were not present for the particular incident to be called murder, this particular accused should be convicted under section 304 of IPC part 2. The court further also reiterated that trial courts should use caution when dealing with situation where there are pleas of mental instability which are given by the accused, and we see that there are situations or the facts and circumstances hint at a lack of motive on the part of the accused. So what we sum up at is that in this case the insanity plea was raised. She did state that there was an invisible power that basically made her do the committing of those acts against her own daughters. The court stated not enough information to us to actually take the exception of section 84, but it is enough to create doubts. The lack of motive, the facts and circumstances surrounding the incident, as we saw the list which the court has looked into with lot of depth, leads to the fact that she didn't have the required intention to commit the crime, and therefore we see the reduction in liability against the woman, right? So we see that lack of motive is now by the Supreme Court in this particular case given a lot of relevance where the plea has been raised by the accused. And this is especially the court has, as we saw in the case where serious offenses have been committed like murder, has to be looked into with more caution by lower courts. I hope students I was able to explain this concept of insanity plea and how it plays an important role when we discuss it vis-a-vis lack of motive for the commission of crime. In this incident, we see that lack of motive could not help with completely establishing the plea of insanity, but it did help reduce the punishment of the individual. From section 302, it did come to 304 part 2 because we could not establish intention against the female. Thank you, students. I hope you were able to understand this particular case.